saw an article online from one of our local Atlanta television stations recently. It was a story about a couple from Arizona, Bob and Linda. Bob's a 75-year-old retired Navy veteran, and Linda is 70 years old. A few years ago, she began having health issues relating to her capacity and was diagnosed with dementia. Over time, Bob could no longer care for her at their home, and he moved her to an adult group home where she could receive better care. Well, as you can imagine, the bills for Linda's care started adding up. Bob wanted to tap into an IRA account that Linda had that was worth about $25,000 and use some of those funds to help with Linda's care. The problem was that Linda had not done any estate planning to provide for situations like this. She never signed a durable power of attorney giving Bob or anyone else authority to act on her behalf and manage her financial affairs. So when Bob went to see a local attorney to get help, he learned that because Linda had not signed a power of attorney, and that because she no longer had the legal capacity to sign one, now instead of getting a power of attorney for her that might cost just a couple $100, Bob was going to need to petition the probate court to have a guardian and a conservator appointed for Linda. In this article, Bob explained that to date, he had spent over $6,100 in legal fees and court costs on this, and he expected that there would be another couple of $1,000s in fees as well. All of this, the time, the energy, and a big chunk of money to access $25,000 or so in Linda's account. Bob told the reporter that interviewed him that, quote, "Older people need help with Arizona probate laws. No one should have to go through this." I agree with Bob on that. People should not have to go through situations like that. The good news is that these situations can often be avoided, and the process to do that is not complicated, time-consuming, or very expensive. For those of you I've not met, my name is Joel Beck, and I'm the founder of the Beck Law Firm, LLC in Lawrenceville, Georgia. In today's presentation, I want to share with you some thoughts on talking with your parents about estate planning here in Georgia and educating you on the basics of the 3 foundational documents that adults in Georgia should have. I want to give you the basic information you need to know so that you can have a discussion with your parents and help them understand some of the larger issues and concerns that they need to plan for so that your family won't have a story similar to Bob and Linda's story. Now for the disclaimer. This presentation is for general, informational, educational purposes only, and it is not legal advice for you or your family. If you want legal advice, consult a lawyer directly and in confidence to receive advice specific for your situation. Now, with that out of the way, let's go ahead and get to it. When we think about estate planning, a lot of people think this just relates to a will or a trust. But a will is just a piece of the puzzle. And the reality is that we need more than that to complete what we might call a basic foundational estate plan. A good estate plan is going to provide not only for the distribution of your assets when you die, but also for incapacity and end-of-life medical issues that adults may face. To help take care of these issues, here in Georgia, we generally use the durable power of attorney and the Georgia Advance Directive for healthcare. And I want to share with you a bit about each of these. The durable power of attorney is a document that lets the client appoint someone to be their agent who can manage their financial affairs in the event of the client's incapacity, or as we do in some situations, for the convenience of the client, even though the client is not incapacitated. With a good durable power of attorney, The agent will be able to manage the principal's financial affairs and do things like manage money in a bank or investment account, pay the principal's bills, deal with insurance issues and retirement benefits, handle personal and family maintenance, handle tax matters and contracts on behalf of the principal. Further, it may also give the agent the ability to access the principal's electronic communications, emails, online bills, and online accounts, etc. This is increasingly important because so much financial management is moving from paper-based to online, and people may get more bills and account statements online or manage accounts only online as opposed to dealing with paper or other records that come in the mailbox. Now, because the power of attorney is durable, that means that it is effective even if the principal is incapacitated. That's what durable means. And ensuring that the power of attorney is durable is really critical, as many people outlive their capacity and need help with these things. Think back to Bob and Linda's story. A well-written, durable power of attorney will generally prevent the need for conservatorship proceedings, and that can save a lot of time, energy, and money. If Linda had a durable power of attorney giving Bob authority as her agent, they almost certainly would not have had to face the issues that they did with respect to going through the costly conservatorship and guardianship proceedings, and likely never would have faced the significant cost that they're incurring now either. One thing to understand as well is that the power of attorney terminates upon the principal's death. A power of attorney does not allow anyone to manage assets after the principal dies. And the principal may also revoke the agent's authority to act as agent under the power of attorney if they have the capacity to do that. Now, last year in Georgia, the Georgia legislature enacted new legislation regarding powers of attorney, and the laws in Georgia were changed significantly for the better. To solve issues of financial institutions not always accepting a power of attorney that was not completed on their own form, and to address other issues, Georgia enacted the Georgia Uniform Power of Attorney Act. It became effective July 1 of 2017. Now, this is a series of laws that is codified as Chapter 6B of Title 10 in the Georgia Code. If you want to look it up, look for OCGA 10-6B-1 and the following statutes if you want to read it. But here's what you need to know. Under the new act, the agent of the principal has certain duties codified in the law to help protect the principal from misuse of assets, and penalties against the agent who takes advantage of or swindles the principal have been strengthened. That's good. Importantly, under the new act, a third party, such as a bank or another financial institution, can be forced to accept the power of attorney and not require the client to sign a power of attorney on their own internal form. That's really good. And this helps solve the problem where the principal may no longer have the capacity to sign the bank's form. But there's a catch, and you need to understand what that is. These new provisions only apply to a power of attorney signed on or after July 1, 2017, and the power of attorney must be the form laid out in the new law or be substantially similar in language to that form. Now, a power of attorney signed in 2017 prior to July 1 or in the years prior can still be effective, but those third parties may still reject it, and there is not a mechanism under the old laws to force them to accept that older power of attorney. So we've recommended that all of our estate planning clients sign a new durable power of attorney that's valid under the new laws if they have the capacity to do that. Now, for your parents, you may want to ask if they have a power of attorney and if they do, when it was signed. If it was signed prior to July 1, 2017, then they very likely need to do a new one if they have the ability to do that. Also, the new form power of attorney provides space for the client to designate someone to be a conservator for them in the case that conservatorship proceedings are initiated. And this may help ensure that the client's wishes are followed and that certain persons do not become involved in the client's financial affairs against the wishes of the principal. Let me turn now to the Advance Directive for Healthcare, which is another foundational document that you should ensure is in place for your parents. The Advance Directive for Healthcare, or ADH, essentially combines a living will and a medical power of attorney. It lets the client appoint someone to make medical decisions for them if they can't do so themselves, and also lets the client set forth how they want to be treated if they're in a couple of conditions, such as dealing with a terminal illness or being in a permanent comatose state. The ADH came to be in Georgia about 11 years ago in 2007, and it's now widely used and accepted. If your parents completed some good estate planning prior to 2007, then they would not have this type of document, but they may have addressed these issues with a variety of documents such as a living will and a medical power of attorney. If so, they may want to consider executing a new ADH to streamline their planning. But if their earlier documents were done well, they will continue to work and they may be just fine for them today. The important thing is to make sure that your parents have selected who they want to make medical decisions for them if they cannot make them for themselves, and also that your parents have specified how they want to be treated. By making these plans, your parents get to have the people they trust in positions of authority for them, and also gives them valuable input into their treatment. And I think this can help reduce the level of stress and anxiety for a healthcare agent so that they don't have to guess how mom or dad would want to be treated. As you think then about having the talk with your parents and broaching the topic of estate planning with them, I think there's a few things to consider. You'll see here on the slide on the screen some of my general thoughts about this. When you get ready to chat with your parents, you might want to consult with your siblings first and get folks on the same page that good planning is important, and then plan to have a talk with your parents. Now, understand, I'm not a social worker or a counselor. I'm a lawyer. But it seems to me that if I'm speaking to my parents about these issues, there are a few things I want to communicate. First, I want to communicate that I'm not trying to take things over. Instead, I want to make sure that if they can no longer manage their financial affairs or direct their health care, that the appropriate plans are in place where my parents have put the right people in place to do those jobs, and that they've documented their wishes in writing in the proper legal manner. I think that when the parent has made their choices, they can certainly take some comfort in that, in knowing that they are in control of the process, as opposed to perhaps having a judge that they don't know determine who is going to look after their healthcare arrangements and who will manage their finances, all of which would be subject to the oversight of the court and would also subject them and their assets to the cost for that process. As Bob said in our story earlier, people just shouldn't have to go through that. Now, one more point I want to make on this, but this is for you and not really for your parents. Understand that it's a good thing, in my view, that you're concerned about making sure your parents have their legal ducks in a row. But let me add this. Be prepared that your parents may not choose you to handle certain things for them. You may not be the person selected to be their primary agent under a power of attorney, or to be their healthcare agent under an advance directive for healthcare. Just because you're encouraging your parents to make sure that they've planned for these situations does not mean that they'll pick you. And it does not mean that you are necessarily the best person for the job. From my perspective as a lawyer, if I'm working with the parents, I want to make sure that they've put the right people in place who can do the jobs at hand. I'm not concerned about stroking your ego. Who your parents choose in these different roles is not about who they love the most or anything like that, I hope. Really, it should be about who is appropriate for the job, about who has the capacity to do this work and the knowledge and the ability to do it. That may be you, but it may also be someone else. Now, let me quickly address some points about wills. A will is the third and final foundational document for most Georgia adults. What you need to know is this: a will maps out a plan to distribute assets when someone dies. The person names an executor to be in charge of this process and to follow the will, subject to the probate court process. Now, as an aside, probate in Georgia, it's not a bad word. It's not unduly burdensome, too expensive, or inefficient. Most people are not concerned about avoiding probate, but some are. And for those people, additional planning beyond a will can be done. I want you to also understand that not all assets are passed down via a will. Those assets that do not go through the will are what we call non-probate assets. Some examples of non-probate assets are life insurance policies, IRA accounts, 401k or 403b retirement accounts, as well as certain bank accounts that have a TOD or POD designation. Those mean transfer on death or payable on death. Also, assets held as joint tenants with right of survivorship, abbreviated JTWROS. Those assets are going to be disposed of pursuant to that titling, and the asset will go to the surviving owner. These non-probate assets do not go through the will. Now, the way that the common non-probate assets, such as retirement accounts and life insurance proceeds, are distributed, that's determined and based on how the person completes a beneficiary designation that's on file with the custodian of the asset. So when you buy a life insurance policy or open up a retirement account, you select who should receive the asset when you die. And you can generally list a primary beneficiary and then a secondary beneficiary or beneficiaries in case the primary died or disclaims, meaning they refuse to take the asset. As your parents think about their will and their estate planning, they also need to consider how they have selected beneficiaries for these non-probate assets and ensure that those are done in accordance with the parents' wishes. It's a good idea to review those from time to time to make sure that the beneficiary designations are still in line with their individual wishes. Now, so far, I've hit on 3 foundational planning tools that we use in Georgia: a will, a durable power of attorney, and an advance directive for healthcare. For a lot of adults in Georgia, those 3 documents are all that is needed. But for others, it may be appropriate to use some additional planning tools as well, including situations where a family has members with special needs or blended family situations, and for persons who own small businesses, for example. There's 2 big dangers that I've seen over the years with respect to attitudes about estate planning, and they're these. The first one is, I've got time, I'll do my planning later. Of course, the problem here is that we don't know if we'll be able to do it later. Unfortunately, we get far too many calls here at my office from loved ones wanting their parent or their spouse or another loved one to get some needed planning done, but we can't do it because their loved one has lost their legal capacity to execute the documents. they no longer have the mental, the legal capacity to sign those documents. Now, capacity is an issue too, but so is sudden death. We just don't know how long we have. And the attitude about taking time is not limited to just putting together initial documents, but it extends to reviewing and updating plans, as well as reviewing and updating beneficiary designations. The second danger that I see is this, and it goes something like this, where the person says, well, I'm not worried about this thing or that thing because my so-and-so, often my son or my daughter or my spouse or whoever, well, they'll do the right thing. Here's what you need to know. When we talk about planning for incapacity concerns, doing the right thing does not mean that it will be easy or cheap or even possible. Think back to the story I shared with you about Bob and Linda. A lack of planning meant going through a costly guardianship and conservatorship proceeding that sucked away a good chunk of change. And I'm sure it also increased the stress level in the family as well. I want my parents to know that the right thing for them to do is to get this basic planning done so that they're involved in these critical decisions, and so that we know that if they become incapacitated, there's a plan in place that can be followed by the people that they have chosen to help them. Well, that's it. We've covered the basics of what you need to know to begin to talk with your parents about estate planning in Georgia. And I hope you found the information shared today to be helpful. If you've got questions, I invite you to contact me. My contact information is there on the screen. I'd be happy to chat with you and see how I might be able to be of help. If you'd like more information about estate planning in Georgia, give us a call and request it. We've got a kit that we can send you in the mail free of charge, no strings attached, that I think you'll find helpful and informative. Now, today we've generally been talking about planning for your parents, but what about for your situation? If you'd like to see if your family and your wishes are protected, I invite you to take our 7-question quiz and see how you measure up. Just go to familyprotectionquiz.com. And there you can take the short 7-question quiz and get some feedback on your situation. Thanks so much for joining us today. And as always, if we can be of help, don't hesitate to get in touch. Thanks.